Okay. This is People of the State of Michigan versus Rayshawn Porter, docket number 20-486FH. And this is the time set for sentencing. Mr. Porter, can you just confirm for me again that you're in agreement with doing the sentencing remotely where you're not actually in the courtroom?
Yes, ma'am, I am in agreement.
Thank you. So, Mr. Porter, you were convicted of domestic assault and battery second offense. That is a misdemeanor punishable by up to 1 year in jail. You have the right to be represented by an attorney. You are represented by Mr. Nickel. And Mr. Nickel, hopefully you got the updated report that I had asked for because the first one had a lot of errors in it. Did you get that?
I did, Your Honor.
Okay. So have you had a chance to review that with your client?
Yes, Mr. Porter and I have had a chance to review.
Okay, and I'll ask you in a second if you have any other changes, but how they got this under current convictions on the face sheet, how they got 4 months, 19 days, I'll never understand. I changed it to 1 year.
It would appear as if 4 months, 19 days is their recommendation because they're recommending 139 days in jail.
Okay, but they put it as the maximum offense.
Yes.
Penalty. Yeah, so I fixed that, and then on the BIR, they have that same thing, 4 months, 19 days. I changed it to a year. And that was it for me. So did you have any other corrections, Mr. Nickel?
Your Honor, the only correction that Mr. Porter and I found is the report that we had reviewed listed 0 days of jail credit. It actually, I believe, should be 36 because the jail credit should have started running the date of the plea when Your Honor revoked his bond.
Right, that's what I was referring to. The first report that they sent said it was a consecutive sentence, and I emailed the probation department and I told them not when it's a misdemeanor. And so they did a new report.
Okay.
And the new report says 160 days credit. So, I mean, the new report fixed the error I asked them to fix, but it isn't real clear.
I think the correct jail credit should be 36 days.
36.
Up until the time of plea,
Yeah.
he would have been serving, the time would have been credited to any parole sanction, not the underlying offense.
Okay, do the people agree with 36?
I guess I'm confused. I think because the point of not getting credit would be that it would be served consecutively, but if it wouldn't be because it's a misdemeanor, he probably should get all the credit, which I think was something that Mr. Nickel and I maybe missed when we first were negotiating this case, is what I think he's referring to. Just the fact that a misdemeanor wouldn't be consecutive, which is why you would get credit for it.
Correct.
I think the issue is the credit statute, I believe, is written slightly differently.
Well, yeah, the credit statute, he gets credit for time that he could not post bond on this offense. So could he not post bond because he couldn't post bond, or could he not post bond in part because there was a parole hold at some point?
He couldn't post bond because I don't think financially he could have posted the bond that existed, but posting it wouldn't have got him out of custody because there was a parole hold.
That's my point. So if he couldn't have gotten out of custody anyway because there was a parole hold, because this was originally a felony and there would be a parole hold, then he doesn't get the credit until I revoked his bond. So I think it would be 36 days. Does that make sense to everybody?
Yes, Your Honor.
Yes,
and I think that was our intention when we were negotiating as well. So that would make sense.
Okay, very good. And so then you had no other changes, Mr. Nickel?
No, we did not have any other changes to the factual content of the report.
All right, Ms. Allen, any corrections to the report for the people?
No, Your Honor, thank you.
Okay, and of course there are no guidelines because this is a misdemeanor. Was there a victim who wanted to be heard?
No, Your Honor, and I will keep my comments about the people's comments as well. We have not been able to secure the victim's assistance in assisting with this case from the very beginning, which is in part how we came to this agreement. I'm happy that we're able to reach an agreement in spite of that. And we'd ask the court to follow the recommendation and the Killebrew agreement with the correction, obviously, of the 36 days credit. Thank you.
All right, thank you. Mr. Nichol.
Yes, I would ask the court to follow the recommendation as well. I think the recommended sentence of 139 days in the county jail with the credit for the 36 days he served since the plea was taken, I think is an appropriate sanction in this matter. Mr. Porter is still on parole, still awaiting the resolution of what the parole board is going to decide to do as far as any sanctions that might result from this. He did, as is noted in the PSI, acknowledge what he did, that it was the wrong thing for him to do, and that he should have, when things started to get out of hand that night, he should have left rather than engaging with Miss Newton. And he did acknowledge that he understands how his conduct would have had an impact on Miss Newton. And so I would ask that the court follow the recommendation, impose the 139 days jail, give Mr. Porter credit for the 136 he served, or the 36 that he has served. Beyond that, I would leave it at the court's discretion.
All right, thank you. And now you, Mr. Porter, was there anything you wanted to say?
No, Your Honor. Like Mr. Nichols had said, I do understand the gravity of my actions. I do understand, the harm that I did cause and probably the issues that Ms. Newton will have after the fact. I just want to say that I'm leaving it in your hands. I feel like anything that you choose as far as punishment is agreeable. I can't recommend how much time I get, so I'll leave it to your discretion.
All right, thank you. I have reviewed all the circumstances here, and I think taking everything into account, an appropriate sentencing that Mr. Porter is still on parole, being supervised, is 150 days in jail with credit for 36 days already served. Mr. Porter, you also by law have to pay $75 to the Crime Victims Fund and $50 in state costs. You, of course, will get all the credit that is available to you at the jail as far as sheriff's good time, any earned early release that you're able to get. So the total may come down. How much, I do not know, but I'm not precluding any of those extra credits. Mr. Porter, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 14 days of today's date. It explains that more on a form that we will mail out to you at the jail. Or is it there? Is there an appellate rights form there on the table or something?
1 second, Your Honor.
Yep.
Yes, right to appeal review.
There you go. There's your form. The only thing you need to know is on misdemeanors, it's 14 days. If it says 42 days on there, it's 14 for a misdemeanor, and your time starts running from today. So you do have the form, and that will, unless you have any questions, we're all set. That'll conclude your hearing.
No, ma'am.
All right, thank you. Good luck.
Thank you. You too.